We are here with T.O. versus and each part will have 15 minutes to present the arguments. The LMA may reserve up to 5 minutes for rebuttal. How long would you like to reserve?
Your Honor, Eric Hall on behalf of the appellant's John. I'd like to reserve 5 minutes.
Thank you. I'll be keeping track of that up here, so I'll try to let you know when you're down about a minute in your initial time. The arguments are being recorded, so please, when you come to the podium, make sure to introduce yourself. Make sure you speak loud enough for the recording to pick you up and that we can hear. And you stay behind the podium because if you move, the recording loses you, so we appreciate you doing that.
Understood, Your Honor. Thank you.
In this case, if you're referring to any children, minors, or victims, please refer to initials or some designation like neighbor or something like that so we know who you're referring to, if you would. The judges have read your briefs and are ready to proceed whenever you are.
Thank you, Your Honor. Good morning. Attorney Eric Hall on behalf of the appellant's Your Honor, it's a brief factual background in this case. Are an elderly couple. They live in the rural area, township area. In that area, you're allowed to do some things that you're not allowed to do in the city. You're allowed to fire firearms as long as you fire them safely. This area where this happened is a rather long piece of land on both sides, both for the appellants and also for the appellee. They share a long border, okay, with a lot of frontage and a lot of property behind them. My clients, the appellants, have lived there for a long time. They're an elderly couple. They're in their 70s. First encounter in this case with the appellee was when in 2020, I think that's when the family moved in. There's an issue with the dog. Appellee had a dog which would come onto the appellant's property. My clients were unnerved, particularly by this dog, and there was some issues with it. First encounter was when the appellee came onto my client's property, the appellant's, pounded on the door, and there was a confrontation where he basically told, the appellee told, F him up and make his life miserable. During the trial in this matter, the hearing in this matter, the appellee, he did not deny making those statements. He said he couldn't recall. Okay. From that point on, from that encounter, things went downhill from that encounter. By the time of 2022, the appellee filed a civil protection order. The grounds for that protection order were really three things. One, that Mr. allegedly climbed over some kind of a fence that ran along the property. It doesn't run the whole property. It's just a small fence, but he allegedly had climbed over that. That he was firing a gun, which was a .22 caliber revolver, towards the appellee's property or even at the appellee. And then the other issue was that the appellee's family, particularly his pregnant wife, was afraid of the appellants. What happened was the police responded to some calls, and because of the civil protection order, that .22 caliber revolver, which was the means of protection, was confiscated, taken away from them. So at this point right now, they don't have any means of protection. It's a rural area. They don't have a firearm because the civil protection order doesn't allow them to have it. Two assignments are there in this case, Your Honors. The grant of the CPO is not supported by credible, competent evidence, and the granting of the civil protection order was an abuse of discretion by the court. In order to grant a civil protection order, you have to do two things. First of all, pattern of conduct. In this case, these allegations involve sporadic incidents. Okay, one was this alleged climbing over a fence, and there was nothing more to it. It wasn't that the appellant climbed over the fence and went to confront the appellee or his family. Just the allegations just climbed over a fence, which was unsubstantiated. That's what the appellee said in the hearing. And then the firing of the pistol, which is legal. There was a wood pile behind, or real close to where the appellant's house is and the porch is. It's behind them, okay, not on the side that you would be pointing toward the appellee's house. You would fire into that wood pile. The police came out and investigated this allegation, of course, of firing at the appellee's property. The sheriff's deputy that testified, I think Deputy Cornelius, could find no evidence whatsoever that there was any gunfire, any evidence that would support that bullets had been fired toward the applicant's property. The other issue was that the other type of pattern of conduct was making complaints. The appellants had called, making some complaints to the Medina County Board of Health. I think, point from memory, that they thought some kind of sewage or refuse was wasn't being taken care of properly. All those complaints were investigated by the Medina County Board of Health, and they came back. They were unsubstantiated. They didn't find any violations. And then there was a single incident of firing, basically what was called a noise cannon. It's not a firearm. It's just something that fires, and it's black powder without a projectile, and it creates a lot of smoke and some sparks. And so my argument, Your Honor, is that those few sporadic incidents don't constitute a pattern of conduct that would justify the granting of protection order in this case.
Was there, though, evidence that there were threats to shoot either animals or people? Because
That may have been with the dog, which the dog wasn't controlled, and this came out, the appellee, I believe the trial, admitted that he could not keep, that the dog had encroached on their property. Not only, the dog did just not come onto the property, it would actually come on and actually menace. I don't think Mr. Hepburn was afraid of the dog, but they did, and I think somebody told him, one of the deputies said that if they were attacked or threatened by the dog, they could discharge a firearm if they needed protection from the dog.
but did the petitioners testify that the respondents threatened to shoot them, or is there some testimony in the record on that?
There was some testimony, there was some, and my client, both my clients testified that was never the case. They never threatened anybody. They never threatened to shoot anybody. There was no evidence, and again, this was investigated because those are serious allegations that somebody was even firing toward a property, and that was investigated by the Sheriff's Department, Medina County Sheriff's Department. There was no evidence, they could find no evidence that supported that.
So then doesn't it turn into an issue of credibility?
I think so, Your Honor, and I think some of the credibility was basically biased against the appellants. The appellee's pregnant wife testified, this goes to the next issue, was that in order to have a protection order, there should be an element of either physical harm or mental distress. She testified from the witness stand, and basically she just indicated she was afraid because the appellants would sit out on their porch, which you could see the property, but the property, there's trees, there's trailers. It's not like you have I guess for lack of better words, a beeline right to their house, okay? And would look at them, and that was the basis of her fear, and the firing of the firearm, which is legal. This is the township. It's legal to fire a firearm there, as long as it's done safely. There was no evidence whatsoever of any physical harm in this case, okay, to either appellee or his family, and there was no evidence of any type of mental distress or mental injury that would have incapacitated either the appellee or his family, that would require any type of mental health treatment. That was never done. It was just the sole issue on that, the sole testimony was just that she was afraid, and she was pregnant, and I think that caused some bias in the court that they have children. My clients are an elderly couple. Their children are grown, they're not there. This family had several children. I can't remember exactly how many, but they ranged in age from, well, obviously she was pregnant, and all the way up to, I think, teens, several children. And I think there was some bias on the part of the court in granting the protection order because of these are people that were the pregnant woman that testified. And my clients, quite frankly, they're an elderly couple, and they came off, I think, in the hearing as a little bit cantankerous, I guess. There was a little bit of a back and forth between John Straight in this case, and he came off a little bit cantankerous, but that's just who they are. These are people that just wanted to be left alone. It's not the issue that they don't want neighbors. This encounter was started by the appellee. You came over and started a confrontation. Like I said, went south from there. My clients would have been happy never to have met them and never to have talked to them, and there would have been no issue. I mean, some people may say, well, that's, not neighborly, but they're not required to engage socially with these people. They just, like I said, they lived there for a long time, set in their ways. They just wanted to be left alone. But the dog constantly coming onto their property, by the appellee coming to the door, pounding on it.
You have 1 minute left, Counsel.
At this point, Your Honor, I don't believe that there was a pattern of conduct that would constitute the granting of a protection order. Also, I don't believe that there was no evidence of physical harm or the type of mental distress that would incapacitate the athlete or his family. It was not supported by competent, credible evidence, against the manifest weight of the evidence, and an abuse of discretion by the court. Thank you.
Thank you. You'll have your full 5 minutes for rebuttal.
Please the court, my name is Attorney Daniel Thiel, 0082869 for the appellee. A civil stalking protection order is a special statutory remedy that is designed to prevent violence. There's a Supreme Court case that I cited, but they were actually citing the 9th District here with JPVTH. That's exactly what this case is about, is to prevent violence. As you see, all of these threats involve weapons, bats, knives, guns. Since this protection order has happened, it has stopped. And there's still some dislike between the neighbors, but there's no more threats with weapons. And that's exactly what a civil stalking protection order is meant to do. The trial court's decision was, they were there. We were not. They took the evidence. One person says the dog only came over one time. One person said many. One person said, hey, I feared for my life. The other person said we never did anything. And so the court was there. And we believe that, the trial court's decision was not unreasonable, arbitrary, or patently unconscionable. Before, you determine the CPO, we asked that, the reason for this is to stop the harassment, protect citizens, protect children at the house. Like you said, his clients are older, and I think you used the word cankerous. I can understand when somebody moves in with 8 children next door to you that are very young and they're causing noise and everything that could cause a disturbance. But this was more than that. He says there wasn't a pattern. I just kind of want to go through the transcript and kind of go through the pattern, because there's a plethora of patterns. Before they even were moved in, there was numerous calls to government agencies to try to get them in trouble, and every time it was testified there was zero evidence of this. There's numerous occasions of threats of violence, shooting of guns, and such. So to establish the pattern, if I could just go through page 17 of the transcript, July 11, said that somebody shot a gun at him. On page 19, line 10 through 11, he says he raised the gun up at me and pointed it straight at my chest. Page 28, line 4 through 6, nuisance report with the health department. Page 28, line 14 through 17, the health department came out and found that it was, as they quote, a waste of time.
So can frivolous legal action be the basis of a stalking?
No, but I think it just shows a pattern. If it wasn't just one, but there was numerous ones continually. If you have to continually defend yourself against actions against government agencies that are frivolous, I would say yes. That, along with the threats of violence, showing a pattern. Page 37, line 8 through 10. The health department was asked if this was a truthful complaint, and they said no, it was not. Page 38, line 14 through 18, August 23rd, 2020. He caught John in the direction of his home, where him and his children sleep. Page 23, line 9 through 4, the shooting had taken place for 10 to 14 days every morning from 6 a.m. to 7 a.m. He talked about a noisemaker. It wasn't just one time. They testified that the guy went by his window at starting at 6 a.m. and shooting this black powder noisemaker. I don't know what those are. I'm guessing it's going to be like a muzzle loader. But from 6 a.m. to 7 a.m. shooting this thing, they're thinking it's gunfire because of the past incidents causing them fear. And I think that's a reasonable thing to be afraid of when believe you've been shot at by your neighbors. They've pointed a gun at your chest, they threaten to kill you, and then they start shooting guns or a noisemaker at 6 a.m. to 7 a.m. for 10 to 14 days straight. Page 40, line 1 through 5, August 1st, 2020. Have threatened to shoot me and my dog. Line 23-24. Quote, I'm going to shoot you and your fucking dog. Line 42. Miss to line 1 through 3. Miss yelling to John to get your gun and shoot the dog. Page 44, line 23 through 25, June 19, 2020. My she called the, had to call the police because somebody actually shot the dog. Somebody shot the dog with a pellet gun.
Do you think the respondents, the appellants, have the right to shoot a dog on their property?
I don't, unless they fear that it's going to cause a harm, I think, because people are allowed to have hunting dogs in Ohio. Coon hunting is something I grew up with as a young kid, and imagine if our dogs got loose and people could just shoot them because they came on the property. I believe that's actually a felony, to shoot somebody's dog. I think people have been tried for that before. I think there was, and I apologize, I can't remember, but I remember reading about it. Somebody was hunting, they were in a tree stand and the dogs came by, and they shot the dog because it interfered with the hunt. I believe that was a felony. So no, you can't just shoot somebody's dog because it comes on your property. You should call it, we have dog wardens for that. We have other remedies besides just shooting. Somebody shot my dog, devastated. So I would hope that would be the rule of the law land. Page 63, line 22 through 25. I heard shots coming from the head. I hear the bullets thrashing through the bush and whizzing by me. Continue on page 64, line 1 through 3. The last shot landed so close to the yard I could hear the impact of the ground just feet from where I was. Most of us wouldn't know what that sounds like. He served his nation, so he knows what gunfire sounds like. He knows when it's close, and he knows when he hears the thuds. He testified to this. The trier of fact believed him. The police, well, he said the police didn't find evidence. Police aren't triers of fact. I think that would give anybody cause of fear, especially a military vet. Page 65, lines 6 through 9. The court even asked questions. So nobody's saying that the court wasn't even involved in this case. The court actively asked questions. The court says, okay, that's what you're saying. You saw him pointing a gun at you. The witness said yes. So the court actively asked questions. They're the trier of facts. They determined who was honest and who was not. Page 90, line 22 through 25, and line 91, continuing on to 41. I had a gun pointed at me. I had shots whizzing by me, and I was working up on my trailer at 8:30 in the morning, going to work. That's why I'm here, because I'm not safe at my home, sir. I know he says that the petitioner is required to show some kind of mental distress, but in the case he actually cited in his brief, Ritter v. Little, 2012, Ohio 131, paragraph 2039, it says, by its very language, RC 2903.211A1 does not require petitioner to demonstrate that the persons to be protected under the CSPO actually suffered physical or mental distress. Dayton v. Davis, and then they say, rather, petitioner merely has to demonstrate that the respondent knowingly caused the person protected under the CSPO to believe that the respondent would cause him or her physical or mental distress. And so I think that the trier of fact, by asking these questions, him by saying that he doesn't feel safe in his own home, and that's why he's here, because they fear for their life, overcomes that. Page 99, April 13, 2020, their daughter came into their house screaming and crying hysterically to the mother, distraught over a situation she heard outside. This goes on line 1725, continuing on to page 100. Said that she heard someone screaming, I'm going to effing shoot you. They ask again what they said, and then they use the actual word. The little girl overheard. She fears. And so when B, the wife, Beyonce, the children's mother, testified that she's afraid to even leave her house, is because of incidents like this. The daughter screaming hysterically that she heard somebody's going to shoot him. The shooting incidents, the people shooting outside of their window purposely in the morning. Page 100 of the deposition, or the transcripts, line 22, B, it said, The police said after speaking to the neighbors that it was in fact made those statements that the child had heard. They investigated. Next we had Mrs. Beswick, who's the zoning inspector for Chapman Township. She testified, page 156. The question was of what complaints have Mr. Heffernan made about valid. Were any of them valid? Answer, no, not really. All the problems I came out for were invalid. So they continually get harassed by the city. Then, you know, the appellants had their chance, and the court, I believe, found them untruthful. On page 184, line 2 through 4, they asked, you testified that you called the police. His answer was yes. And then 187, the question again was, you would agree with me that the record doesn't reflect that you were the caller. Answer, I have no idea what the record reflects. Page 202 through 200 through 202, the court goes into detail about all the times the police were called and the other departments were called. So the trier of fact got to hear this and ask questions about it and determine who they believed. Page 214, Mrs. The court asked her, ma'am, you're saying that you were shooting to make noise because of the animals. The court then on line 25, shooting the .22 pistol to make noise. They were asking her what the reason was for her shooting and stuff, and they determined they didn't believe that she was shooting to make noise. They believed, you know, that this protective order needed to be in place, that it was done to intimidate or to cause fear. Page 220. On page 220, admitted to brandishing a knife and having a bat. Line 12, I had a fishing knife with a serrated knife on it, with a serrated on it after. I don't know what that meant, but like I said, all of these incidences involve weapons. They involve children, involve neighbors. It is correct that he went over there and knocked on the door as a neighbor. When you know, you get all these calls from city officials and they keep coming over, maybe go over and talk to your neighbor and see what's going on, see what you can do to make it better. And instead they get met with a knife and a bat. As it is, they never try to talk to them again. The one part that scares me, that kind of shows the intimidation, is when the shooting was going on, that he supposedly was shooting at a wood pile, and the shooting was whizzing by him and going to the dirt. He came out and says, "What are you shooting at? What are you shooting at?" They both gave blanks, as it says in the transcript. They said nothing. They were silent. They turned around and walked back into their house. They didn't say, "Oh, we're shooting at the wood pile, I'm sorry," or anything like that. That's kind of what gives me rise to show that this was not just shooting into a wood pile or anything like that. I asked the court, you know, to keep this in place. It's working. There is no more threats with weapons, and I thank you for your time.
Thank you.
Your Honors, I remember you asked about the issue of credibility well, if you think about credibility, all the complaints, all the allegations that gun in the employee's chest, that he was going to shoot him, he was going to kill him, all these calls, apparently, they did not believe, law enforcement did not believe what the appellee was telling them. If they believed it, and they thought it was credible or had any credibility, they would have charged threatening somebody, menacing with a weapon, attempted felonious assault with a weapon, almost never charged with any of these things because the officers did not believe. Next, it wasn't just the dog that was not controlled. The dog was not controlled, but it was also their livestock. This issue where the daughter came in and cried, my understanding of that was that she overheard to shoot a chicken, okay, that had encroached on their property, and what I think was in the garage or maybe on one of their cars. It was not threatening to shoot any children or any other athlete's family. The next issue was about the complaints to the health department. A civil protection order is not the correct remedy for that. The correct remedy would be to file civil action against harassment, abuse of process, defamation. I mean, if the investigations are coming back that they don't have any basis, then that was their remedy, not a civil protection order to stop somebody from calling in and making complaints. Civil protection is to protect somebody against physical violence, okay? Fear of physical violence, not because somebody's calling in complaints to the health department about your property. That's not a correct remedy. My client, because of the civil protection order, their constitutional right to bear arms has been taken away from them. Okay, they're out in the country, they're an elderly couple, okay? There's a lot of land, there's huge frontage at this property from where the road is. So they're at the mercy if somebody decided to go there and rob them or do something to them. You know, they don't have a firearm to protect themselves. By the time the police would get there, or the law enforcement would get there, it may be a tragedy. That was taken away, and I talk to them on a monthly basis, and they're terrified that they don't have a firearm. That's one of the reasons they wanted to appeal this, is so they can have the opportunity to get that firearm back so they can protect themselves. They have no family, their children are grown, and they're out there by themselves. They've been there for a long time, but if you think about it, you see this area, for people that are, you know, elderly and somewhat infirm, one of the reasons they asked if they could come here today, but they're too infirm to get here. They have a difficult time getting to court, so they needed that firearm just to protect themselves. So, you know, this protection order, I think that the court lost its way in this. I think they abused their discretion because they heard these allegations, and they're just allegations. None of this stuff was supported other than by the testimony of these things happen. But again, law enforcement came out there, and these were serious allegations. Somebody shooting at him, shooting at his family, shooting toward his property, putting a gun in his chest, threatening to kill him or shoot him. Never charged because law enforcement did not find these allegations credible, or would have charged them. I'm asking the court to reverse the decision and vacate this protection. Thank you.
Thank you, Counsel. And thank you both for your presentations today. The court will take that matter under advisement and issue a decision in due course. When that decision made, the clerk of court will mail a copy to you, and also that opinion will be posted on the High Supreme Court website at that time. Having said that, the court is now adjourned until